Hello, this is the AI Lab. Today it's my pleasure to welcome João Pedro Quintais. João is Associate Professor at the Institute for Information Law, better known as IVIR, where he studies how intellectual property law applies to new technologies. João is also co-managing editor of the widely read Kluwer copyright blog and has published extensively in the area of information law. The reason? An AI article entitled Generative AI, Copyright, and the AI Act. Let's hear what João has to say. Hi, João. It's quite an article that you have written, and it's been quite a process to write it. Can you summarize the key interactions between the AI Act and EU copyright law, and in particular when it comes to text and data mining or TDM practices?
Well, thanks so much. Pleasure to be here once again. So I think without going too much into detail, the basic interaction takes place at what you'd call the regulation of the input or training phase of an AI model. So what you have on one hand in the Copyright Directive of 2019, the Copyright in the Digital Single Market Directive, is a set of provisions as exceptions and limitations for text and data mining. So you have an Article 3 that is aimed at research organizations and cultural heritage institutions that is mostly aimed at text and data mining for scientific purposes. And it has a number of requirements, namely one I think we'll talk about later, which is that you have to have lawful access to the materials that you text and data mine. And on an additional provision that covers all entities, that applies to all entities and would cover also text and data mining for commercial purposes, is in Article 4. And the main difference in that Article 4 is that it's subject to additional requirements. Well, both the beneficiaries of the exception are broader, but on the other hand, you have additional requirements. And the one beyond lawful access to works that is mostly debated is that you have to allow rights reservation, or what is called opt-out, mostly for content that's publicly accessible online. So the way this works is that if you do, for example, web scraping online from a publicly available website, there would have to be a mechanism that would allow the opt-out of rights holders. How that works is a different question on how that might work. Now, obviously, the directive was initially proposed in 2016 and approved in 2019 and implemented even later. And only already at the implementation stage, and when we were discussing the AI Act during the legislative process, what happened is this boom from the commercial side of generative AI tools. And the drafters of the Act, which really also not initially thought about generative AI, realized that this is something that they had to deal with. And especially from a copyright perspective, there were issues surrounding the use of massive amounts of copyright works to train AI models, and then the possibility that once those models were incorporated into systems that were used by everyday users, that they would generate outputs that would be similar or identical in some cases to copyright protected works on which the models had been created. So the way that they dealt with this in the AI Act, which is not a copyright legislative instrument, but does contain two provisions in Article 53 that aim at tackling certain copyright issues. They are in Article 53, 1C and D, and basically those provisions state that general purpose AI model providers, so these are the only entities that are covered by the AI Act, must put in place a policy to respect copyright law, in particular to identify and respect through state-of-the-art technologies this reservation of rights mechanism, or opt-out, expressed in Article 4 of the Copyright Directive. So there's an explicit and direct link to Article 4. And in addition, there's an obligation that these providers must throw up and make publicly available what's called a sufficiently detailed summary about the content that they use to train their models. Now, I think there's two additional aspects, at least, that you need to bear in mind here. One of them is the fact that the definition of text and data mining, which is found in Article 2 of the Copyright Directive, is quite broad. So it would apply in theory to a number of activities that are involved in the that take place in the pre-training and even the training of the model. The AI Act mostly confirms this in Recital, I think, 105, where it says that in simple terms, that if you're doing text and data mining, you're basically doing activities that are considered consistent with the pre-training and training of a model. It says it in other words, but this is basically what is mentioned. And so by doing that, the Act is, in simple terms, bringing the concept of TDM into the process of pre-training and training an AI model. Right? And in addition to that, what is important to bear in mind is, because the concept of TDM is so broad, it will apply to a number of entities along, let's call the value chain of life cycle of building an AI model in an AI system. And those entities are not only the general purpose AI model provider, if they are doing text and data mining or TDM, but also entities that would be, I would call it, upstream. Think of the lay-ons and common crawls, entities that would be involved themselves in web scraping or data set creation. Those entities would be doing text and data mining under the definition of the Copyright Directive, but those are not the entities that are providing, their qualify as model providers, and they would not be subject directly to Article 53 of the AI Act. So there's this really important difference about who are the targets of the AI Act and who are the targets of the Copyright Directive, which would be broader in that sense.
Maybe let's then delve into the more detailed aspects of the AI Act, which is that we know it includes a transparency obligation for, as you mentioned, general purpose AI model providers. And that obligation is to publicly disclose summaries of the data used in training, or at least to disclose summaries, maybe not publicly. That's another point of discussion by some. How do you see this shaping the relationship between AI developers and rights holders? Because you mentioned the opt-out. And how do you see that compliance with TDM exceptions happening? Because there's no details, obviously, in legislative act. It's a level of detail too far. But how do you think that will pan out in practice?
Okay, so it's a super interesting question. Well, I think, like, on the transparency point, I mean, some precisions might be in order, because I think they will matter in practice. So the first point to mention is that this is the provision in Article 53 1D of the AI Act that states that these GPAI, general purpose AI model providers, have to draw up and make publicly available this sufficiently detailed summary about the training data, including pre-training, for GPAI models. And this will be done according to a template provided by the AI office. Now, this obligation is not just about copyright, right? It's about training data in general. So when drawing up the rules for this summary, the template for this summary, I think you have to take into account not just the legitimate interests of copyright holders, but also those of privacy and data protection, research, prohibition of discrimination, respect for diversity, and even fair competition. So there's sort of a balancing act in when drafting this document, whereas some information might be really helpful for copyright holders, but might be a step too far for what is needed to balance these other interests. Now, on the other aspect is that this is a transparency provision about the training data, which is not necessarily the same as transparency about the opt-outs. Now, this seems like we're splitting hairs a little bit, but it's also something you already see in the code of practice. So for the opt-out provision itself to be relevant, you would not only have to know about the training data, but you'd probably also have to know about if there's a rights reservation mechanism or opt-out in place, when was it in place in the particular website, and was it, or so that we know that if something was scraped from that website, the opt-out was already in place or not, to give you a specific example. That is not clearly something that falls under this obligation, but might be derived from the other policies to respect copyright obligation. And that's at least how the people drafting the code of practice on GPAI models are taking that into account. But let's put that aside for a moment. I think the minimum contents of this obligation, I think, have to be sort of on this reasonable threshold of knowing that because of the way that copyright works, low threshold of originality, territorial fragmentation of ownership also, no registration requirement, it's sort of impossible to think about listing all the copyrighted works that were scraped from the internet, to use the example of web scraping in the pre-training and training process. So what the Act tries to do here is to say, well, the summary has to be generally comprehensible in its scope instead of technically detailed. It must include copyrighted and copyrighted protected content. And then it must be drafted taking into consideration protection of trade secrets. It's really unclear to me exactly how much that is going to affect the contents of the summary and the level of disclosure that GPAI model providers have to take in place, especially because trade secrets often are used as a barrier in this area. And so this is something that should hopefully be addressed, at least at the level of the code of practice. And the examples that are listed by the legislator include listing main collections or sets for training the model, large and private and public databases or data archives that were used. And then there's this idea that there's a narrative explanation about other data sources used. Now, in my view, what's the usefulness of this, right? The usefulness of this from a copyright perspective is really how to clarify some aspects that could be essential to know whether or not the TDM exception requirements have been met. First, where did the web scraping take place? That matters because of the territoriality of copyright. So if the relevant act of text and data mining takes place somewhere outside the EU, it is not absolutely clear to me whether the EU law applies to those activities. I think we'll get to that a little bit later. Second, even if EU law does apply, what we would want to know is with this information is whether or not this data was obtained from a lawful source. There was lawful access to it, which is a requirement of both Articles 3 and Article 4 of the Copyright Directive. And to know that, this is extremely useful to have access to at least a certain level of fine-grained or detailed information that would allow me to make that judgment, especially in relates to web scraping, which is something that has been heavily debated. Third, if there is a time period of access together with the information about respect for opt-outs or not, then it might be useful to determine to what extent you've also complied with that requirement. So what I would say is that in theory, a training data summary that is minimally complete can help establish to what extent you've complied with some of the requirements of the TDM exceptions. Now, this is a little bit tricky from a legal perspective, also practically, and it's tricky because the AI Act obligations are separate from the Copyright Directive obligations. So in a way, by giving too much weight to these, you're helping determine to what extent you've complied with the obligations in the Copyright Directive, which leads to different consequences, right? If you infringe the AI Act, it's basically a public law instrument that has its own sanctions and remedies, but mostly no private right of action and infringement of copyright are derived from there. But they might help determine whether or not you breached the conditions or didn't meet the requirements of the TDM exception, and in doing so, be decisive in determining whether or not you're infringing copyright at the level of the TDM. So it makes the interaction extremely complex, and it makes how you draw these requirements important. Now, whether or not in practice this will help, it really depends on the level of the detail of the summary. If it's too vague, it's meaningless. If you don't have to disclose too much, it's also pretty irrelevant. But if it is well drawn up, it might be quite useful, I would say, especially for the level of these players here. Now, of course, and I would end with this, again, this is an obligation imposed on the GPAI model provider. So if the provider obtains the data sets, for example, from parties that are upstream, as I mentioned before, the example that everyone discusses is Leon, but then Common Crawl and the like, then the question that is before us is, okay, the provider itself didn't do the scraping, it's just obtaining the data set. So how do you deal with this relationship between the GPA model provider and its upstream providers that are not subject to the AI Act? And that is still something that has to be figured out.
Thank you. You've clarified things, and at the same time, you're kind of confirming how complex the whole chain is going to be, and the set of obligations. Let me delve one step deeper. You've mentioned the extraterritoriality and the importance of location. Where did the text and data mining take place? Recital 106 of the AI Act introduces what some call an extraterritorial element by requiring compliance with EU copyright standards, even for AI models that are trained outside the EU, or at least that's what the text seems to say. You actually wrote a separate blog post on this recital and on that extraterritorial element. So if you look at the idea of the territoriality principle in copyright law, how enforceable do you think that this recital, which is only a recital, can be in practice?
Yeah, this is sort of a hornet's nest, right? As you mentioned quite correctly and succinctly, like Recital 106 of the Act basically is meant to supplement the interpretation of this copyright policies obligation, and it says that even if the relevant text and data mining activity takes place outside the EU, the example is always a jurisdiction that in theory would have laxer requirements, be it, although probably not anymore the US, but Japan is an example, Israel would be an example, and depending on how things pan out in the UK, could be an example. The idea of this recital is that, okay, even if that activity takes place outside, the rules of the AI Act apply. Now, obviously, the logic is understandable, right? The Act is a sort of a product safety approach. And the idea is, and it's stated in the recital, that we don't want the provider to gain a competitive advantage in the EU by applying lower copyright standards than those provided in the EU. So it's basically a prevention or avoidance of regulatory arbitrage, and that is very consistent with this product safety logic. And some authors call this a market entry requirement. Others consider it like with some level of creative interpretation that this basically allows EU copyright directive rules like those on TDM to acquire direct effect vis-a-vis private legal entities outside the EU. I'm a little bit more doubtful. And the reason why I'm more doubtful is that if you depart from the principle that copyright is territoriality, there is something like the rule of infringement of lex loci protectionis, which is the law of the country of which protection is claimed. Without being too technical, this basically means that you have to take into account the law where the activity takes place to determine what is the relevant copyright rule. And in copyright, this is a very clear principle. So you have national rights in the EU and you have a high level of international harmonization. So the normal consequence of this is that if a certain act of text and data mining takes place outside the EU and exclusively outside the EU, then that activity has to be regulated by that law, not the European Union law. And of course, the problem in the particular context of AI is that you could very logically build a model, do the entire pre-training and training, fine-tuning and everything up to the model being developed outside the EU, and then release that model in the market in the EU. And because these rules in the AI Act, these copyright provisions and the TDM provisions in the Copyright Directive would regulate the training stage or the pre-training stage, then you would say they don't apply at the model stage or at the generation of output stage. So they wouldn't apply once the model is released in the European Union. And this is what this recital tries to avoid. Now, obviously, my main problem with this is basically that it sort of contradicts these general tenets or principles of copyright law. And it's also included as a recital. So there's nothing in the actual provision itself of the AI Act that states this. So this generates, from my perspective, a set of problems, right? First is that doing this in a recital that didn't make it to the text is basically going beyond what recitals in European Union law are able to do, which is to be, they are assistive to legal interpretation, but they cannot be norms themselves. They shouldn't be normative exhortations. So that is the first problem. The second problem is this territoriality principle. So if you are doing this, you're basically changing the fabric of copyright law through a regulation that is not a copyright regulation and by operation of a recital. So you create a super lex specialis based on a recital, which is something that from my perspective, it's not sort of legally consistent. Now, obviously, um, we are faced therein with a problem, right? Do we ignore the recital or do we have creative interpretations to make this recital work? I myself, but that might be my problem, I haven't really found a good interpretation to this. Some authors, like Professor Poikert that you've had previously on the lab, has an interesting approach, which he calls sort of an intermediate solution, which says we only apply this provision on the AA Act if the model provider has scraped websites that are hosted on servers located in the EU. And I think that's all nice and well, right? But I already think that's the normal application of the law. If you consider European copyright law to already state that relevant act of web scraping qualifies as text and data mining, and if you scrape a website in the EU, that would be text and data mining in the EU, and you're captured. So I already think the law works like that. Others might disagree. So I don't think there's really an intermediate solution. Here's the normal application of the law would say, if you do TDM activities in the EU, then you're captured, so to speak, by EU law, and the Act would apply. But the obvious circumvention tactic is to go elsewhere, and there's not really a great solution to that. Like, the obvious solution is to solve this through contractual means and sort of what's been called meta regulation, which is sort of what I think the code of practice is trying to do. The code of practice is restating article recital 106, but then moves on and says, well, what we should actually do is have these GPAI model providers make sure that when they use these data sets and contract upstream with their own third-party providers to obtain the data to train their models, they are actually taking into consideration and taking a commitment or best efforts commitment to make sure that all of this and the activities that were taken, the TDM activities of these other providers, are in compliance with EU law. So sort of contractually having an obligation of due diligence, but also sort of assuming the liability risk and exposure for the content they use in their product to use the AI Act logic. But this is something very, very different than saying that the law extends to acts that take place outside the EU. And I think this voluntary meta-regulation approach is a more consistent way to make this whole puzzle work. But as you can imagine, this is far from an ideal solution.
Thank you, João. Puzzle is definitely a good word to to qualify the interaction between and you know, it's one of those puzzles with 1,000 pieces, and when you come at the end, you notice one of the pieces is missing. That's how the recital feels. Like, oh, we forgot the article. It seems.
Indeed, maybe I can just add something to that, which I think we also, and you know this better than me, there's a political economy element to this, right? One thing is what the law says, and here is a legal scholar telling you that there are all these limitations, but the other is also the spirit of the provisions and the policy environment in which this takes place. And it seems quite clear that even if the law doesn't mandate extraterritoriality, and if you have very good arguments to say that this only works in this very sideways manner, that a GPAI model provider looks at this and looks at the potential fines under the AA Act and understands that there are strong incentives for me to comply as best as I can with these measures. And in that sense, doing their own risk assessment about compliance. And I think from that perspective, even all these efforts with the code of practice and all this discussion might lead at least the bigger GPAI model providers, but certainly a good part of them to understand that it is best to take this compliance approach from a best efforts perspective in order to avoid severe sanctions and remedies. So from that perspective, I think the Act might even achieve some of its aims, even for copyright holders.
Well, on this positive note and this wish for compliance and compliance spirit for 2025, thank you so much, João, for clarifying all of these elements. I think they're really helpful, especially with the code of practice discussions still ongoing and the code still being drafted. And look forward to reading you in 2025 and reading more analysis. And have a great year.
Thank you very much, and likewise.